All right, class, welcome back. Today we're going to talk about Chapter 11, Civil Liability and Accountability. As police officers, we can be held civilly for things that are done wrong. Basically, if an officer mistreats someone, they have violated that person's civil rights. That person can then sue the police officer. They can sue the police officer supervisors, the chief of police or the sheriff, the mayor or the board of supervisors, whichever one it may be. And that person could possibly get a large settlement or a large amount of money. There are two main avenues for civil litigation against police officers. One is sometimes referred to as United States Code 42, Section 1983. And under that, it basically states that a person can sue a police officer or any type of federal agent acting in their power, but there has to be some type of qualified immunity. In other words, officer has a lapse in judgment or makes an honest mistake. Then someone can also sue under a state tort. There are certain things which must be proven, such as the public duty doctrine. These are some of the defenses. The public duty doctrine, contributory negligence, um, assumption of risk, and sudden peril. So just because an officer is in his official capacity as an officer does not mean that they sometimes mess up. They do often make mistakes, and for those that do, I feel sorry for them. I feel sorry for the people that they hurt, and it's just a terrible mess when that kind of thing happens. But it does happen, and we have to face the facts. Now, a lot of people will hear the term color of law, and the United States Supreme Court has said that someone acts under the color of law when he or she acts in an official government capacity and with the appearance of a legal power. And that's where civil liability for police officers come in. They have to be acting under the color of law when they've done something wrong. It does not necessarily mean that it's restricted to police officers. It could be mayors, it could be the chief, it could be supervisors of that particular person. Those people have to be acting under the color of law um, and to be civilly litigated for those particular crimes. Now, one of the things that uh, one of my supervisors, one of his interview questions was always, do you know what culpable negligence is? Well, culpable negligence is when a supervisor basically has to answer for his subordinates' actions. So just because you're a supervisor does not mean that you are immune from any type of civil litigation if an officer messes up. You still can be liable. The chief can be liable, as I stated, and this is known as culpable negligence. So just keep that in the back of your mind if you ever do become a supervisor, that you can still be held accountable for your officer's actions. That's the reason why it's so important to make sure that you get the right officers, get them the right information, and get them trained. Now, another case that we want to look at real quick is Bevins versus 6 unknown named agents. And this happened in 1971. And up until this time, you could not sue a federal law enforcement officer for any type of violation. But under under the Bevins case, the Supreme Court held that federal law enforcement officers can be sued for Fourth Amendment violations. So that was a landmark case for civilians and their rights once this case went to court. Now, other things that can help within um, keeping police from misconduct are certain external accountabilities. One of those is a Citizens Oversight Committee. Here in Tupelo, where I once worked, we had a Citizens Oversight Committee, and they would basically review the actions of police officers who had done possibly something wrong, and would make recommendations to the chief or the deputy chief on how that should be handled. This citizen board monitored not only the officers, but it also monitored the chief and their actions once they were given that particular ruling that they wanted to give. Another thing that you have is internal affairs for the police. These people are not usually liked within the police department because they do investigate officers and their wrongdoing. A lot of folks think of internal affairs as the snitches of the police department, but actually what they're doing is they're actually doing a great deed for not only the police but the citizens as well, by making sure that police officers are doing what they're supposed to be doing and not jeopardizing anyone's civil rights, anything like that. Another thing that we have at the police department is agency accreditation, which basically means that we have been accredited by a national convention, and that commission is otherwise known as CALEA. I believe it's also stated in your book under agency accreditation. CALEA stands for Commission on Accreditation for Law Enforcement Agencies. This basically sets standards for police officers and what they do. And if you're an accredited agency, that basically gives you a little bit more status as to saying, hey, these are the things that we do religiously as a standard. So being an accredited agency helps most officers in their cases when something does come up. So if you ever get to go to a police department that is accredited, they will have specific procedures which they want you to accommodate and to abide by. So, all right, class, that's it for this week. Make sure you read chapter 11. Take your quiz. There will also be a discussion board on if you were over a police department, what kind of rules would you set up? And I'm going to be interested to read those and see what some of you come up with. It's always nice to have a fresh idea, and hopefully you can give me some ideas on that. So until next time, thanks.